She was just 12 years old when she and a friend lured their classmate into the woods, then stabbed the classmate nearly 24 times while her friend egged her on. The case made headlines everywhere when the young girl said they did it to make a faceless and fictional character happy. Now, years after the shocking stabbing, a judge made a jaw-dropping ruling for the then preteen who nearly killed her classmate.
This was a serious criminal case, attempted murder. There are two defendants in the case. Both were children at the time that it happened, 12 years old. The victim was a child.
Morgan Geyser wasn't even a teenager yet when she and her friend Anissa Wire lured their classmate Peyton Lautner to a park in Waukesha, Wisconsin. It was there Morgan stabbed Peyton 19 times while Anissa egged her on. The two left Peyton to die inside that park, but she was able to escape and flag down someone who called 911. When authorities caught up to Geyser and Wire, the two told police they did it to earn the right to be servants of this sinister but fictional character, Slender Man. They told police they feared the tall and faceless character would harm their families if they didn't carry out the attack. Thankfully, Peyton survived. Meanwhile, Geyser and Wire were both charged in adult court with first-degree attempted intentional homicide. In December of 2017, Anissa Wire was sentenced to 25 years in a mental hospital after pleading guilty to being a party to attempted second-degree intentional homicide. However, Geyser was convicted, but found not guilty by reason of mental disease or defect, and sentenced to up to 40 years in a psychiatric hospital. In 2021, Anissa Wire was granted supervised release after only spending 4 years in a mental hospital. Under her release, she was ordered to live with her father, receive psychiatric treatment, and submit to around-the-clock GPS monitoring. But the monitor was removed in September of 2023. Now Morgan Geyser is hoping for the same. She applied for release 3 different times. Her first 2 petitions she withdrew. Then in April of last year, Judge Michael Boren denied her request.
This court is satisfied by evidence that's clear and convincing that Ms. Geyser does pose a significant risk of bodily harm to herself, to others, or of serious property damage for the reasons that I've stated. Now, as she works hard, she continues to do what she's supposed to do, but that doesn't change this risk. Remember that what the community is concerned with risk, dangerous risk. The community is concerned to a great extent as well with what happens to Ms. Geyser. But the primary concern in the balancing, and we talked about balancing earlier, in the Randall case, they talk about the balancing that goes on in the court's decision. The ultimate determination of dangerousness requires a careful balancing of society's interest in protection from harmful conduct against the equity's interest in personal liberty and as well as autonomy. So that's the balance. But the balance is the public interest in staying away from harmful conduct. Under these circumstances, this court satisfied that the scales tip in favor of the public, and it tips that way by clear and convincing evidence. So in this matter, after hearing all of the credible evidence, which I'm satisfied was very well presented by both the state as well as by the defense, I'm satisfied that the petition should be denied.
But she reapplied 6 months later, and it appeared 4th time was the charm. At Geyser's latest hearing for conditional release, the state called Dr. Brooke Lundbaum, who appeared virtually. Back in April of last year, Dr. Lundbaum testified the now 22-year-old hasn't thought about the fictional Slender Man for a while, but was adamant there were still concerns about her release. However, at Geyser's latest hearing, Dr. Lundbaum said she was in support of Geyser being granted conditional release.
At this point, I am in favor or in support of her petition for conditional release. Specifically, I don't believe that she currently poses a significant risk of substantial harm to herself, others, or to property damage. So at the time of the index offense, there was consensus amongst a variety of professionals involved in the case that she was experiencing symptoms of a psychotic spectrum disorder that was eventually pretty consistently diagnosed as schizophrenia. The symptoms that she displayed of particular relevance were delusional ideas related to the fictional character of Slender Man, but also a variety of auditory and visual hallucinations, disorganized thinking, disorganized behavior, and instability in her emotional regulation.
Were those symptoms things that were observed objectively as well as reported by Ms. Geiser subjectively?
Yes.
And were those symptoms something that professionals believed prompted the index offense?
Yes.
As of today's date, are you aware of Ms. Geiser reporting any symptoms of delusions or hallucinations or any kind of psychotic symptomology?
In review of the records, the last time that she either evidenced or expressly discussed overt psychotic spectrum symptoms was in about 2021, I believe it was. So there's been a several year period now where there's been an absence of those acute or overt psychotic spectrum symptoms.
Okay. I want to ask about the discussions that you have had in the past with Ms. Geiser during this period when she claimed to have fabricated the symptoms. What explanation did she give you for the index offense?
So that has shifted a bit with her self-report, again, not being particularly credible within the context of this kind of conversation. She, at various points, though, maintained that she was being sexually abused within her family home and had essentially engaged in the index offense with desire to essentially escape her home life. Again, that not being consistent with the totality of information that exists.
Have you ever asked Ms. Geiser why she would claim that she had fabricated those symptoms?
We did discuss that during the current clinical interview for the current petition. Um, she had vocalized that um, it's been difficult for her to appreciate and understand the different experiences and symptoms she's experienced over time, in part due to the young age that she was when the index offense occurred, in part due to memory not necessarily being fully formed or being impacted by the severity of her symptoms over time. Also, there's been changes simply because of development and maturity, changes in her chemical makeup as she's continued to get older. Her current understanding is that she experienced fantasy related to these different fictional characters. And within the context of her mental illness, fantasy essentially became blurred with reality, where she had a difficult time determining the difference between essentially what's fiction versus what's real.
Dr. Lundbaum did express concern that Geiser could be vulnerable to manipulation or exploitation based on not developing the same types of relationships or friendships that others have experienced growing up. She testified Geiser had been making better headway with her mom, her grandmother, and her brother since her dad passed away.
In and of itself, fractured family relationships wouldn't necessarily augment a person's risk if there's additional levels of support that they can rely upon. In Miss Geiser's case, she would have the benefit of rather significant professional support surrounding her if she were to be discharged to the community. Um, Ideally, she will continue to bridge those gaps that exist with her family members and continue to strengthen those. However, frankly, a lot of people in the community don't have great relationships with their family. And in and of itself, like I said, that doesn't necessarily suggest that she would uh, have be a higher risk for violence. It's just one factor to consider, especially when we're creating a risk management plan for her discharge to the community.
Although Dr. Lundbaum agreed Geiser should be granted conditional release, she testified everything will still be a process for Geiser, and she'll likely need therapy the rest of her life.
It is a process that will continue likely throughout the entirety of her life, but certainly throughout the last, whatever it's been, 8, 9, 10 months, there has been a noticeable improvement in her understanding of her mental health, how she discusses her mental health, diagnostic labels aside.
Lundbaum was the only psychologist called by the state. Geyser's attorney then called Dr. Kenneth Robbins to testify. He also testified in Geyser's hearing last April. At the time, he said that she had enough treatment, and this time around was no different.
Well, she has very significant anxiety issues, and she has had, I think, what can only be called a bizarre adolescence, and needs help with um, uh, sort of developmental issues. She has had very limited exposure to peers. She's had very limited access to education and independence. And so she's going to need a lot of help in uh, becoming the mature person that she wants to be. Essentially, that she has had multiple opportunities to be in the community and has done very well. And that I think there's nothing to suggest that she is a danger to herself or others. And I think there's very little at this point that Winnebago can do for her. And that's what they would say as well. I think it's in her interest and in everybody's interest to try to help her now become the person she can become. Yeah, I guess there's no, first of all, there's no treatment any longer that Winnebago has to offer her that's going to be useful. So there's nothing that she has to gain by being there. Second, there's nothing to suggest that she's would be dangerous outside of Winnebago. Done nothing to suggest she's dangerous at Winnebago to others. And since 2021, nothing to suggest she's dangerous to herself. And third, she's a young woman with great potential, and she's not going to realize that unless she has an opportunity to get into the world and start to have more interpersonal interactions that are appropriate with peers, that she has more education opportunities, that she has the opportunity to be independent in a more significant way. I don't think she's going to become dangerous to other people, whether she's at Winnebago or not. I think that there is the risk that over time, if she is limited by the things that Winnebago can offer her, I could imagine her becoming hopeless at some point and potentially becoming a danger to herself. So yes, perhaps ironically, I think she would be safer outside of Winnebago. I'm concerned about that. I'm concerned at some point she's going to start feeling hopeless.
The final psychologist to be called was Dr. Deborah Collins. She's been evaluating Geyser since 2014. Dr. Collins said Geyser told her she can't forgive herself for what she did to Peyton Lautner when they were 12.
Morgan continued in that, I believe in that meeting with you, to acknowledge the harm that she caused to the victim. And you state in your report that Ms. Geyser said she hates it. Her friend was the only one who cared and was loyal, and trusted her. She hates that she did what she did, and feels that she was a different person back then, 10 plus years ago.
Yes,
After the offense, she struggled for years to forgive herself. Isn't that what she expressed to you?
yes,
There's chunks of her childhood that she has trouble recalling now when she reflects back on some of the events that happened.
yes,
When you do your risk assessment, or when you perform risk assessments to try to figure out if a person is going to be a danger in the future, you do want to look at stressors that is it important to talk to someone about stressors they might face in the future?
Yes, if they're amenable or will talk with you.
Did you ask her to recall any stressors that she might face? Did you ask Ms. Geiser that question?
Yes.
And how did she handle that? Or how did she respond?
Well, what she told me is that she recognized that she hasn't been an adult in the community. She's essentially spent the last over a decade in institutional settings. So she knows there's a lot she doesn't know, if you will, about handling adult responsibilities. She also knew that her case is likely to garner her attention, unwanted attention in at least some or many instances. And she likened that to in the institution where, of course, as patients come into the institution, they become aware that Ms. Geiser, the Slender Man case-related person, is in the institution. And so in the institution, she's garnered unwanted attention from other patients. Over time, she's learned a principle for her is that she doesn't want to talk about it, at least not with those patients, and that she doesn't want her the index offense to be the source of unwanted attention or to feed that.
Like Dr. Lundbaum, she previously testified Geiser wasn't ready for release just yet. But this time around, Dr. Collins said she's ready.
The protective factors include her intellectual resources and her capacity for problem solving. She has improved coping skills for managing stress that she has worked on and developed with the assistance of years of treatment and the treatment team she has at Winnebago. She has demonstrated improved capacity for self-regulation, emotional self-regulation. So managing stress in the institution, decreased frequency to use fantasy or to use, I guess I would say fantasy or retreat into herself for coping. And she also has an express motivation to proactively pursue a pro-social life course moving forward. Her compliance in the institution is remarkable, both with medication and with treatment. Her lack of behavioral management problems in the institution, her lack of violence toward others in the institution and toward herself. Those all bode well for her readiness for conditional release at this time.
And it seemed more mental health professionals were on Geiser's side, including 2 social workers from the Winnebago Mental Health Institute, who also testified in favor of her release. But when it came time for arguments, the state was firm. They didn't want Morgan Geiser to be released.
As the court pointed out last time, and as Randall indicates, the court is not bound by the conclusion that the experts have reached, even if those opinions are uncontroverted. So certainly the court has to make up its own mind as to whether or not the evidence at this point indicates a substantial risk of bodily harm to herself or to others. And last time, Judge, you started your analysis looking at the factors as they're set out in 971.17 sub 4 sub D. And after it indicates the court shall grant the petition unless it finds by clear and convincing evidence the person would pose a significant risk of bodily harm to himself or herself, the statute indicates the court may consider without limitation because of enumeration. Number 1, the nature and circumstances of the crime. That's where you started your analysis last time, Judge. And it's the state's position that this offense alone is enough to demonstrate by clear and convincing evidence that there's a substantial risk here to others and to herself. The court pointed out that this was a brutal attempted murder. The effort to stab somebody 19 times. But then she's not dead, but then they leave. Of course, with the idea or thinking that she'll bleed to death. You know, when I think about this, Judge, I can't help but thinking most people in society are not capable of committing the offense that Morgan Geiser committed.
Well, at no surprise, Geiser's attorney argued she should be given a chance to be outside the mental health facility.
And Dr. Lundbaum with that very long history, has conducted a number of evaluations and at least 2 conditional release reports, if not more. I think more than that, actually. And last time Dr. Lumbaum testified, the state called her last time as well to meet their burden of proof. She indicated that she did not support release. So what does the state do? Now, in January of 2025, they call Dr. Lumbaum again. And now their witness takes the stand and testifies under oath that based on her deep analysis in this case, understanding the statutory criteria that needs to be considered, she cites it on page 1 of her opinion, the state's own witness testifies in support of conditional release. And I think almost everything Mr. Sapakowicz just said is a red herring to get this court to be scared somehow into doing what I think is the right thing to do.
The judge acknowledged the state's argument Geyser did attempt to murder Peyton Lautner.
This was a serious criminal case, attempted murder. There are 2 defendants in the case. Both were children at the time that it happened, 12 years old. The victim was a child. But the case didn't resolve itself per se in the criminal field. It's not a criminal conviction. In this case, based upon the nature of the law and what happened, the court found that Ms. Geyser was not guilty by reason of mental disease or defect. Then that moves it into the commitment field, the civil field that we're addressing today under Chapter 971, in particular 971-17 of the Wisconsin statutes. So this isn't about somebody going to prison. It's about somebody being committed to a mental institution, to a hospital, and how that person functions within that institutional setting.
But in a stunning ruling, the judge sided with the defense.
In reviewing all of the reports and the matters, I'm satisfied that under the circumstances that the great court's going to grant the release. I'm satisfied that by clear and convincing evidence that under the current set of circumstances, Ms. Geyser does not pose a significant risk of bodily harm to herself or others, or of serious property damage. Now, when I make that finding, I take into account what happened. I take into account the dangerousness of what happened back in 2014. I take into account, though, what's happened since, and in particular in the last 6 months, I take into account the opinions of the doctors, but in particular, and it's been an important analysis for the court to make, that as the Randall decision talks about, that the ultimate determination of dangerousness requires a careful balancing of society's interest in protection from harmful conduct against the acquittee's interest in personal liberty and autonomy. In looking at the Randall case and of what happened in Randall, when I contrast Randall to Geyser, there's a tremendous difference in the rationale for rejecting supervised release in that case, in Randall's case versus in this matter. When I weigh that dangerousness concept and I come back to what happened and what the progress has been, Ms. Geyser doesn't fall into the same category as Mr. Randall in his petition for release and the denial of that release. So on that standpoint, I'll grant the petition so ordered.
So now what happens? Well, Geyser didn't get to just walk out the courtroom to begin her new life. The judge ordered the State Department of Health Services set up a plan to house her in a group. The judge will look over that plan at a later hearing slated for March 3rd, where the judge will look over the release plan, which requires his approval.